Mzansi, we're back again. It is that time of the night where we have to talk about what happened in that court. And I see Emily is in trouble. Are you in trouble, Emily?
Yes, I am, fam.
Yeah, we are late because of one, internet, guys.
And two.
Yeah, it's mainly it's internet. I'm trying to find something to assist you, Emily. I don't know how I can assist. Let's see. Okay. Can you yeah, are you fine now?
Yeah, I can work with it like this.
You can work with it.
Yeah. Guys, I'm sorry.
We are.
I'm having trouble with my
We
headsets,
are having
but we'll
trouble.
get it fixed.
Yeah,
if we let these things get to us, then we're not gonna do anything. So might as well
trouble in
just-
paradise. We were here at 11.
Yeah.
Been waiting for God knows what.
First it was the internet,
Yeah.
and then now it's this issue that I am having. But it's fine. We soldier on.
We
We've
soldier
been
on.
through much worse than this. Let's get started. Guys, welcome back to the Mzansi Reality YouTube channel. Thank you so much for joining us here again for another one of our deliberation on the Senzo Meyiwa trial. And I apologize.
Yeah, guys, it was beyond our
Control. Our hands.
We started with something like 20 something megabytes, which couldn't even give you anything in this day and age. So we had to start turning our internet upside down until we got something. So we are here. Apologies. In that, we are saying apologies. Right. So you might be seeing things, and I'm even seeing things that I'm not even supposed to see. But yeah, let us continue.
Rekupa mswarelo. Okay, guys, Advocate Nisi picked up from the issues related to the documents he asked for, the warning statements. And he started off by asking Brigadier Gininda, in 2021, Mr. Ntanzi, you took him, or you have taken him for dental observation at Rustenburg for dental observation, not mental. Not mental, dental. And Gininda said no. It's partly correct and not 100% correct in that he was arrested on the 16th of June 2020 by Sergeant Mabena and Sergeant Mohani, and he said that they dealt with this previously, and that was in relation to the Nongoma case, which they also dealt with in the court, because some witnesses seem to suggest that on the docket on this matter before court, that either the first intruder or the second intruder may have had a gold insertion. A gold insertion is what they called. Basically, they're talking about a gold tooth. And he said that they not only one, some referred to the second suspect. So another one referred to the first suspect. Because of that information that they had, he was then taken. He said that he was present on that day on the 22nd of June 2020 for dental examination, and that is how the witness that came to testify came into the picture. And that was to check as to whether, as it's mentioned in the docket, that the second intruder may have had a gold dental incision. Now, this person that came to testify is referring to Dr. Tlokwe, the dental or the dentist who testified as a surgeon. Do you guys remember him?
Yes.
Then Nisi said, what were the results of the medical investigation? And Gininda said that it was negative. He said that they also dealt with that. There was a report, as he said, the witness testified, and he indicated that he found, but to his recollection of the report, he could not find that there was a gold tooth that was removed, because the accused too did not have a gold tooth at the time. So he said his recollection of the report did not say that there was once an artificial object in his gums that was removed. Note that. That's what he is saying.
Who Who's saying that?
Brigadier Gininda. Before the judge interfered, of course. But yes, that's what he was saying. To his recollection of the report, there was once, it did not say that there was once an artificial object in his gums that was removed. He's talking about accused number 2.
Okay. That's what he said after the judge insinuated that. The judge.
No, this was before the judge insinuated. The judge insinuated something else. But initially, Brigadier Gininda had said, the report said that there was no insertion of an artificial object in his gums. But the story, of course, it changed after the judge said something.
What did the judge say?
Well, Nisi continued to cross-examine Brigadier Gininda, and he said, your recollection is spot on, and that was 6 years after the incident of the killing of the deceased. The incident of accused number 2 being taken for dental medical observation happened 6 years after the killing of the deceased, and they found that he never had any insert of a golden nature in his teeth. Well, Gininda said that that is correct, and then the judge interfered, okay? He said about gold inserts. Black people in the main, they have cosmetic application on their dental. You have never seen a black guy like me having a gold teeth. And Gininda said that he had, and the judge said, yeah, it's not a miraculous phenomenon. Gininda said, indeed, my lord. Then the judge said, and after some time, you will erase that. Gininda said, correct, my lord. The judge said, we all know that, right? And Gininda said, yes, that's true, my lord. We have seen that. So, yeah, the judge literally here was trying to say...
Then after that, that's when Gininda wanted to explain something new, which is this artificial part, artificial teeth. This was the judge's doing.
Gininda had previously said that the report did not say that. And then the judge made these comments, and then somehow it triggered something. And then he started to change his story. But for the judge, I'm sure that if that was the case, Dr. Tlokwe would have picked it up. There's a reason why dentistry, they study for 6 years. They study so that they are well equipped to pick up if the teeth had any types of incisions on them or in the past or anything like that. So even if it was a fake, I'm trying to assume that maybe they were presuming that he had a fake gold insert, the one that you did. There was once back in the day, but they used primer stuff and they would insert them and stuff like that. A lot of people's teeth got damaged from such. So I'm sure
I don't know why in court we are creating such scenarios.
Me too.
I just don't even want to give airtime. It is just a circus because the judge, he looks like he's helping.
Yeah, he is helping.
He's helping Gininda.
He's helping.
Because after that, he wanted to explain something when we had moved on from that. There was a consensus that there was no gold insertion.
And then Gininda came back and said exactly what the judge was saying. But then the judge was now saying to Mr. Ramosepile that he looked surprised after he made that comment about black people having self-inserted gold teeth. And Ramosepile said that he wasn't perplexed. What perplexed him is the qualification by his lordship to say that after some time it is taken out.
Exactly.
And the judge said, yeah, it's fashion.
Exactly.
Have you ever seen a lady with a piercing in her nose? After some time she removes that same with teeth. So he was comparing a piercing with a gold teeth.
What he's trying to say is that accused number 3 could have this artificial teeth that was there, that could be, or paint in a sense, that could be wiped off. And then that's why I'm saying it's crazy.
The thing about if he's trying to insinuate a fake gold teeth incision, the dentist would have definitely picked it up.
But why are we going there? Why is the whole judge going to do that? Why is the whole judge going to take us to places where there has never been a theory coming from the state that says that? Why is the judge the one taking us to that direction?
We are
thank you.
We are holding on for dear life.
God bless you. It just doesn't make sense. You know, it is sad to see this man trying by all means to assist the state. It is very sad, and I cannot emphasize it any further. It is sad, and anyone who does not see that, then I don't know.
Maybe they work for the state or the departments that are assisting with 636 Kwazban. You know how things go in this country. You never really know who stands where. But then this is sad to actually watch a judge assisting like that. To such an extent that they even willing to speculate. That was
the man reads. Yes, Ned. A man reads the statements on record before the attorneys have. The defense could have seen. And we are here because of certain statements that now are being qualified. He's the one who called them. He wanted them to be read on record. He's the one. He's, in a sense, a pillar of this case. He's a pillar. He's the one pushing it, in my opinion. It looks like that. He's the one balancing it. When it's about to fall, he comes into rescue. That's how it looks like.
Ramasipili said, but here, medically, in relation to my colleague's interaction with the witnesses, that medically it was proven that accused number 2 never had such an incision. And the judge asked Ramasipili if he read the medical report. But Umbamudimu, of course he did. How? That's his witness. That's his client. It was concerning accused number 2, that dental report. How could he have not? Wait. Well, Ramasipili responded to him and said, yes, I did read that the report, and Dr. Tlokwe was here. We cross-examined him. And the judge said, okay, fine, yeah. No. So Mnisi now went to the Dagama SCOP. From a police station in the Western Cape. This is a warning statement that Gininda had said, brought in as part of the exhibits, just to demonstrate that not all the police stations are using the same warning statements. Like, according to Mr. Mnisi, it's prescribed that the warning statement, according to the law that he knows, should be one. And I even remember the late Mkomezulu emphasizing on the warning statement. Do you guys remember that? And there's something then Mnisi today just demonstrated to us exactly what was wrong with this theory that Brigadier Gininda has, that the warning statements are different for different police stations all over the country. Well, Gininda wanted to close the part of the golden tooth right. He was not done. Nisi said that we are slanganisa, meaning that he was messing them around. He told him that the issue had been closed with regards to the gold teeth. And if there's something that he wants to bring to the attention of a record with regard to the golden insert, the state will have an opportunity to re-examine him on that. And he is now on the Gamascope document. But then Baloyi objected and said that they submit that the witness is entitled to elaborate. They have just dealt with the issue of the dental examination. Now something has occurred to him, and he wanted to go back and elaborate on what his answer was. And he said, we submit, my lord, that the witness is entitled to elaborate on that and should be given the opportunity to elaborate on that. So the judge asked Mnisi for his response. Mnisi said that he was at the hands of the court. So why does it seem like Gumele etoli tuba, to introduce something new or to try and correct and to, and these little things are the reason why we are observing and we are seeing that aibo haikona. This is not right. It doesn't feel right. It doesn't look right. It doesn't feel right. Well, Ramasepile actually said that the statement of the deceased witnesses were allowed in during his cross-examination. Well, Ramasepile didn't say it. This deceased witness statements, do you guys remember that they were allowed because of this whole thing of allowing Brigadier Gininda to go on and on and on and on explaining something that he was not asked? Do you remember that, Mr. Anonymous? And now it seems like another opportunity here was being squeezed in with regard of this gold tooth. So the judge reminded Nisi of the case 1927 R versus Hepworth. He had even forgotten the name of the case. He just said that case from 1927, what is it? And the case is clear. He said that you can't stop a witness. This is not a game. It's not saying that. And he said that Yena, he's an administrator of justice and he's not an umpire in a cricket game or a soccer game. If the witnesses are allowed to say anything, then the witness is allowed to say it. So Mnisi said that he is at the hands of the court and he can elaborate if that is what he wants to do. Well, then Gininda started going on about as much as he has the medical results in the docket or the investigation, there's not evidence that says that the incision either by the first intruder or the second intruder was medically inserted. Taking exactly from the hints of the judge. He said, I just wanted to qualify that it does not mean that we have evidence that the first intruder was taken to a medical practitioner and the gold tooth was medically inserted. So it could have been an artificial one that could have been removed. So I just wanted to qualify that. So he said, he went on and on about explaining it. But did you guys notice the judge was writing down his own suggestion that he made to Brigadier Gininda coming from Brigadier Gininda's mouth? Did you guys notice that?
Oh, welcome. That's what has been happening. All day long, anytime he suggests something's taken, he writes it as if it's new stuff.
Brigadier Gininda said, we thought obviously that these are done medically. Let us see what the medical examiner will find. But the absence of the finding does not mean that it does not exist in either of the people that were seen. That is all I needed to say. So all he needed to say was what the judge hinted to him. Yes. But then what they forget is that Dr. Tlokwe actually, according to his profession, is trained to have seen such, and I'm sure he would have noted it is in his report. The damage on the teeth as a result of having a DIY gold tooth is severe, honestly, more than that was inserted on a medical or the one that was done by a medical professional. And they always pick them up, according to my experience and what I know and what I've been told in the past, that the damage is severe. You'll need something to clean that tooth out. And people always complained about how expensive it was and how much they regretted having fake gold teeth, because now when you have to clean it up, it's a lot more costly. They should have just went for the medical one instead. A lot of people are used to have regrets back in the day about such things. So yeah, unless if they're saying that Dr. Tlokwe is not competent, asazi phela. So this evidence, whenever it favors some people, and it always is wishy-washy. A witness can testify as a surgeon, as a dentist, and then 360 brigadier, the lead investigator, is now speaking on their evidence on things that They did not write on the report. Then Nisi said that now you realize you are tempting me to ask you the following questions. You realize that whether or not that there was a gold insert on somebody's jaw, that's medical evidence. Is that not so? You're a brigadier. The doctor said it wasn't there. That's what medical expertise is saying. So your opinion in that regard matters not, because yours is just an opinion from a man who's never been a doctor. And Gininda said that he doesn't know where that statement is coming from to say that he's not a doctor, because he never claimed to be a doctor. He said, I never interpreted what the expert said. But that is an interpretation. Your own interpretation with the judge. It's not what they expect. It's not what he said.
Let us press that like button. Guys, please, reminder, just press that like button. Take your time and press that like button. And yes, we do take membership. Thank you very much for those who have joined. Thank you very much for those who have gifted. Thank you. We appreciate you. Even in this time, in the morning, we are here. We are grinding, guys, for you. Thank you.
He said, I simply said that the fact that the doctor said there was no medical evidence, there was no gold insertion, it does not mean that there was no artificial one, because we do not have evidence this side that says the gold insertion in any of the intruders was medically inserted. All we have is the description that one of the intruders may have had a gold insertion. He said, I simply said that the fact that the doctor says there was no medical evidence, that there was no gold insertion, it does not mean that there was no artificial one, because this, we do not have this side of evidence that says that the golden insertion was medically inserted. All we have is the description that one of the intruders may have had a gold insertion. So here you have a medical report on the end to say, I have examined this person and this is the medical qualifications and I have this finding. This side we have a description where we do not know if indeed this was medically inserted. Now, to say that I'm now trying to pose as a doctor, I think it's uncalled for, because at no stage did I contradict or misinterpret what the medical dental surgeon said. No, you added new information on what the medical dental surgeon had compiled. You added extra information that we don't know where you took it from. It's that simple. So funny how also the forensic pathologist, guys, do you remember the forensic pathologist was never allowed to give opinions on what he thought of the examination he did on Senzo's body, especially the wound, like what type of bullet wound resembled the type of firearm that could have been used at close range, considering his experience of working perhaps with similar wounds in the past. You know, he was stopped. He was not given an opportunity to give an opinion. Do you guys remember that? But a brigadier can give an opinion on a dentist's report. What is not good for the geese is not good for the gander. The opposite is happening in this court. So yeah, Missy asked that. He said that he didn't know where Kenna Roots got the warning statement from, and Gininda said that he was not requested by Advocate Missy as to who is handing over that statement. But subsequent to that, the adjourning of yesterday, because he was realizing that this is becoming an issue of debate between him and Advocate Missy. So he said that he embarked on the process to request statements from all the stations, from the exhibits or the exhibits that he had brought to court or that he had obtained. One from Bravinet confirming the exhibits given to them so they can authenticate that these statements come from them. So Gininda said that he had embarked on that process. As they all become available, he said that he will share with Advocate Mnisi. So Mnisi then said, Brigadier, that was not my question. You just had a sermon, our Father who art in heaven, and you said in Latin brilliantly. Of course, this was a figure of speech, okay? It was a figure of speech where he was trying to say that Brigadier Gininda just gave a long answer that did not answer his question. He said, my question is simply that you said yesterday that Lieutenant Rona did not tell you, or she did not bring it to your attention. Who did she get this document from? Is that not so? So Baloyi stood to object at this point, and he said that he thinks that those remarks that Advocate Mnisi made with regards to comparing his answer to a long sermon, they can't be ignored. Once again, he said it's important for counsel to extend courtesy to a witness. The witness was asked a question and he was answered to his best endeavors. And now this somewhat demeaning preposition is what is made to a witness. That is uncalled for. And Advocate Mnisi should withdraw that. And Mnisi said that he said nothing that is demeaning here. And I agree with him. I feel, in my opinion, this is gaslighting. In my opinion, they were trying by all means to get on Advocate Mnisi's nerves in all angles, instead of telling their witness to answer questions. They would rather accuse him of doing something that I don't think he did. He had the opportunity to be mean. He wasn't mean. Was that mean, Mr. Anonymous?
No, it was not.
And the judge said that there is something wrong about it. Of course, he sided with the witness, and he said that the witness never recited the Lord's Prayer. For some reason, they decided to blow up this example Mnisi made out of proportion. And the judge now said it's sarcasm. His view is that he's belittling the witness. Sarcasm refers to the words that mean the opposite of what you really want to say, especially in order to insult someone or to show irritation or just to be funny. I did not see that. I know sarcasm, okay? I can be sarcastic myself sometimes, but it's not what happened there. The Lord's Prayer in this instance was just being blown out of proportion. Maybe Mnisi used a bad example, but then I just felt like every opportunity to upset him, they definitely took it. So Mnisi repeated the question once more, and Gininda said that he said this so many times about the manner that Advocate Mnisi wanted to deal with the issues, and he has pleaded with him that they should focus on the business at hand without being... It's amazing how he was speaking like he's the lawyer. He was speaking like he's the one dealing with the witness that's being evasive. He said that he answered the question and does not understand the selective listening by Advocate Mnisi. I'm sorry, guys. I found this part really funny because he said he wanted the question and he said yes. He doesn't understand how he compared what he's saying with the Lord's Prayer. Even if you don't believe in God, I just don't see how you narrate the two. He said they should, they should focus on the business at hand and stop arguing on pertinent issues. He just chose to be upset and evasive, focusing on the Lord's Prayer and all. And when it was a figure of speech to help him understand that he was not answering the question, he just gave a long answer with no answer, no substance. In fact, he was too kind to Advocate Mnisi in the manner how he said it, because Gininda honestly does not answer questions. So Gininda went on to do another sermon saying that he thought that they were here to assist the court in coming to the truth. He does not understand why, when he wants to indicate something that will assist the court in getting a clear picture, that information must be suppressed. What are we to do? What do we have to hide? We are here to assist the court. Like, what are we here to hide?
To flip off a script.
I just feel so gaslit from within. I'm like, who's hiding stuff in this court? Exactly. Like, so he said, we are here to assist the court with the facts and all that I'm saying or arising from the questions that I'm being asked. And I will narrate that to that picture and so that it is clear. He said he doesn't just come and say something that arises from questions that are put to him. So Mnisi said to him that he's not sure whether he's done. It seems to him like he's got a lot on his chest that he wanted to take out. And he said, you may proceed to take it out. We are very patient. And then he said, take it out before I start with my cross-examination. Well, Gininda said, no, you can start. I'm done. All I'm saying, he wasn't done. He said, all I'm saying is that the plea that I'm making is that we can focus on the business at hand and leave pertinent issues. He said he'd do the same thing. If he were to do the same thing to advocate Mnisi, it might not sit well. And he thinks that as court officials, both of them, him, and he said him, myself, the senior, and the senior for that matter at this level, he referred to himself as a court official. He said they can adjourn at least and maintain the decorum of this court and focus on the issues at hand. And that's all that he was asking for, to maintain the decorum of the court, because he said it'll give him the same courtesy and then, deal with the issues that are beforehand. At some point, I'm like, some of how he's saying it, it sounds like a threat, but I don't know how to consume this sermon. Should I be scared or what? I'm like, Mr. Mnisi, what is going on? I just found it hilarious, you guys. But then, then he said that he was done after that. Mnisi said, back to the Gamascope. Mnisi asked him, do you see that one of the warning statements does not have a police insignia? They didn't know what a police insignia was, and I didn't know also. It's a police badge or a police symbol on the document, apparently supposed to be there. And the document that Brigadier Gininda handed up, it didn't have the police badge. Well, then Gininda said that that's correct, but it does not mean that it's not a police document. It is a police document because he has seen it in his experience, and he's seen warning statements without a police insignia, which are coming from the police. So what he can say is that it is a warning statement that has been used at a time when Colonel Root obtained it, and hence he said that we will get affirmation in the form of a statement from that station. So Mnisi then said to him, you told the court yesterday that there's no authority that says a specific document must be used when obtaining a warning statement from a suspect. Gininda said that there's no authority that prescribes a specific document as the only document that must be used when a warning statement must be taken. And he even referred to the booklet that they were dealing with, the 3M, that it is not prescribed as the only document that must be used by the SAPS. To date...
Well, someone sent me something just on that. One of our subscribers is like, it's a warning statement. This is coming from in Iqabane, 2023. I think that's the letter, that book that Mnisi was referring to.
Yes.
Which is number 5. Point number 5. It is important to note that whenever a member takes a warning statement from a suspect, only the official statement regarding the interview with the suspect, SAPS 3M, in bracket M, close bracket, may be used. This form contains the comprehensive constitutionally warning which must be conveyed by the member to suspect. It is imperative that SAPS 3M in bracket M be used to record the warning statement of a suspect. No other unofficial form may be used for this purpose. Failure to use the standard official form may result in rendering an accused person's trial unfair, e.g., failure to advise a person from whom the warning statements are taken, that his or her statement could be used against him or her subsequent trial. This is now S versus Oria and another 2005 in bracket 1 SACR 63 CC. So now who's fooling who? Now this is these are there's even a note there that says, please note that the National Instruction 6 of 2014, paragraph 5, and further into okay, this is now small, into further in respect of instruction that are applicable to interviewing of a person in custody. See also discussion of the prevention of combating of torture of a person's Act 13 of 2013. These things are down. These things are there. Why are we brushing them off as if they're not there? That's why Mgomezulu was insisting on these things. It sounds like he is what Brigadier is saying is not there. You know, it sounds like that. So all that these people are saying they are doing, it's illegal. It's not supposed to happen. You know, you cannot remember all these warnings that you need to read for a person that you are arresting. No, you can't. Even who's smart.
The contention that has been happening between the accused, especially accused 1 and 2, as well as these police officers that arrested them, including Brigadier Gininda himself as the lead investigator of CAS 636.
So it's a lie.
So they are saying that these people didn't read us our rights. Isn't that what they are saying?
Yes.
And then Brigadier Gininda and all the police officers who made the arrest, Momokhani,
this form would have assisted if it was done properly, like with this form, because it would have then been an issue of, but your signature is in this form that has all these warning statements.
For them not to deny that their rights were read to them.
Yeah.
So here I am thinking that we are in a position where we have to believe one or the other, but it looks like someone didn't do their job properly.
Yes, that's basically what Mgomezulu and is now is hingering on.
Because now, for me, it's new information that actually when the police interrogate you or when they interview you, they are supposed to fill in that warning form each time they do. I didn't know that before. How many of you guys knew that? I didn't know that. And it looks like Ontanzi and Sibia didn't know that as well, that there's actually a form that needed to be filled in each time that the police were having interviews with them, asking them about the case. And that was not done. He's telling us about his diary. He's telling us about, yes, he read the rights and we're supposed to believe that, even though a warning statement would have helped us assist or would have assisted him in helping us understand that he did read him his rights. So yes. who must we believe now? The way things are done, it's almost as if there's no time to do things properly. What is going on? Well, Nisi said, let's move to ZZ3, which is another warning statement in the Graf Reinelt case. He asked Brigadier Gininda, who assisted you with this document, and Gininda said that it was also from Colonel Ruot, and the statement from the police station was emailed to them. And Mnisi asked, I want the name of the person who gave Ruot the statement. And Gininda said he got an affidavit from that police station attached and the same warning statement saying that this is what they are using. And Mnisi reminded Gininda that he was lamenting about being treated with dignity, respect, the speech and the courtesy and all of that. Honestly, Mnisi just wanted the name of the officer who gave Ruot that warning statement in that particular police station.
The impression I'm getting is that cold case unit,
yeah, but
they cannot even.
There are no rules.
Yeah, they just come and take what they need to take from any police station. That's what Nisi was trying to look at. I think that's what he was trying to highlight, to say these people don't have a certain procedure that they follow. Even the warning statements that they are saying, they did not. In fact, they would go as far as trying to prove that by going to these courts and pulling some information that doesn't have a signal, and they come back and they say, take it. When you ask who gave you this, who was using this, it's not clear. And then the judge takes it and he puts it on record.
In fact, he's not being encouraged to answer the question. If he doesn't know, he doesn't know. It's that simple, right? He should say, I don't know. But he wants to give this long explanation of nothing really. But that's not the question that you were being asked. And that's what Nisi was hammering on the entire time. I admire the patience of that man. I don't have it.
Let's press the like button, guys. Let us press the like button. Let us go with the numbers that we are seeing here. Please press the like button for this video to be pushed. Thank you.
Nisi is very patient, guys. Today we luile impi. Yesterday I will luile. So Gininda said that he had answered the question, and Nisi asked him who is the name of the person, that if he has answered that question. Well, Gininda eventually said that no name was given. He went back to saying that no request was made for him to get the name. Now an impression is made that they collected certain things without collecting them properly. And he said that he told him that he made a request and the issue he's dealing with is authenticity. Nisi asked him if he was done and said briefly, what you are saying is that you do not know the name of the person. And Gininda said, what I know is that Stefanos Kruger is the one who deposed the affidavit after my request.
From the cold case unit.
Attaching and confirming that the document that Colonel Rhodes gave me is the one that they are using at Refrenet. So he's also from cold case unit.
Yeah, I think it's between Rhodes and someone is the one who was working on that side. Cold case unit.
As far as the name, she didn't give him because it was not requested by Advocate Nisi, is what Gininda is saying. But Stefanos Kruger is the officer that confirmed that this is the document that they are using, and this affidavit is coming from the Grafrenet police station, is the one that he's saying that he had given it to the state in the morning so that they can share with the defense. So this statement or this affidavit that are supposed to explain the warning statements arrived in the morning. So the judge asked to have sight of the document. He said that he had not seen the document, and Gininda was referring to, and he said, before I'm accused of colluding. He's now throwing shade. He's saying that an affidavit by Ruot was read in court by the judge, and Lieutenant Ruot Mariki, the judge emphasized that she's a senior and not a constable, and she's part of the National Cold Case Unit. Now, this document was signed on Tuesday, the 21st of January 2015 at 9:19. So it was signed on the morning just before court started. So Detective Kruger, who's a warrant officer, wrote the letter. There's a part where when the judge was reading, he was reading it in Afrikaans, but then there's also an English part. The entire statement, I think it was written in English except for where the Afrikaans part was being read by the judge. And I quote, I will go directly to where he was addressing or explaining the witness statement. And I quote, it said, "We are presently using an abducted warning statement, and it is widely accepted in our district. The advocate that our original court at the time of introducing the abducted warning statement, Mr. Bakers, had approached us with concerns regarding the shortcomings with the warning statements we were using. He stated that it did not conform to the Section 35 of the Constitution of the Republic of South Africa. A short while later, we received the present warning statement from his office, and in conjunction with myself, we managed to compress the contents into the present 3-page document, which encompasses all the requests of the court. Each police station had previously used a standard warning statement which was both in English and Afrikaans, but this one did not conform. So we discontinued the use of that one and opted for a new revised one, which is presented only in English as per the national instructions. Attached, find a copy of this warning statement currently being used at Grafrenet SAPS." So this police officer was explaining how they had to compile a new warning statement and not use the one that was prescribed because it was not sufficient. Guys, are the police allowed to do that? Can they just change warning statements like that without it being like attended to by the national offices and something? I was expecting that before a general statement like a warning statement is adjusted and made changes to, that there would be consultation with the legal of the national office first, so that it is drafted properly, made properly, and then distributed throughout the entire country. Why is it a police station gets or uses their own legal to change a warning statement? This doesn't feel right. In fact, it's sounding rather scary in my opinion. I don't know. I just feel like, are you guys getting the same feeling? Like I just feel scared all of a sudden. How do you, as a police station, change and design and draft your own warning statement? Is that even legal? Like, I'm so bothered. And also, I was expecting Brigadier Gininda to be the one to put that statement on record, but then the judge is the one reading it on his behalf. What is going on, guys? And then Advocate Nisi said that the affidavit was never brought to his attention. So Advocate Nisi is saying that Advocate Baloyi didn't give him that statement in the morning. So it looks like it was just placed there. And then now, as Brigadier Gininda is being cross-examined on it, it just pops up. And then Advocate Baloyi is saying, no, I gave it to Mr. Mnisi in the morning. And Advocate Mnisi is saying it was never given to him. He said that he wouldn't have insisted on asking about the person who gave Ruot the warning statement had he known that the affidavit that is explaining that warning statement was there and it was given to him and he was given time to go through it. So Gininda said that this is what he tried to explain over and over again, which is why him and Advocate Nisi were bumping heads, because he seemed to think that he was explaining unnecessary things, yet he was explaining things that he seemed to not understand. Because there seems to be a gap from what he knew and what he was telling him. He knew that there was an affidavit and he knew that he should have it, and it was clear that he was asking what should be before him. So Advocate Baloyi earlier indicated that the affidavit was given to Advocate Nisi. At some point, even Nisi asked Baloyi to be sincere with the court, to please be honest, because according to Advocate Nisi, saying that Advocate Baloyi just put the papers there and never really distributed them and gave it to them, so it was very awkward. And then Mnisi said that what comes from paragraph 4 as he was listening to the judge reading the statement is an indication that the document does not come from the SAPS. It's a creation of Graf Renet police station in conjunction with prosecution. So Gininda insisted that it is not prescribed, it's not a prescribed form in the SAPS, and paragraph 4 indicated exactly that, which is what Advocate Mnisi brilliantly pointed out, in my opinion. So Mnisi then said, thank you. At least now we are making a bit of progress. He moved on to another warning statement that is from the Nelspruit police station, and Mnisi now again from the Nelspruit police station warning form. He asked him, who did you get this form from? And Gininda said this one was gathered by Sergeant Mongwe. He's saying is Mongwe. Don't know if it's pronounced like that, but that is what he was saying, and no name was given to him. But subsequent to yesterday's proceedings, he said that they found that it was done in Nelspruit, and they asked for an affidavit from them. So the judge asked Brigadier Gininda why he calls that document a warning statement. That was awkward. Why does he call it a warning statement? He said it's a form. Even he can say that. So we are not crazy after all. And Advocate Mnisi was not crazy after all. So he's saying it's a form, and Gininda said, yes, it's a form, my lord. And the judge said, and I'm sorry to interfere, but this document is like the judge's rules that were incorporated in 1931. He started so well, and then he goes left. He was now trying to say that for warning forms, right? We move from a warning series to a warning form. As long as you used the judge's rules, then it's fine, even if it's different for different police stations. So this part, he was trying to justify that form. And he said, and all that Section 35 of Constitution has done is to take water mayor's thinking. That's all. Judges' rules, even today, they are still applicable. So Baloyi said that they were approved at a conference in Cape Town, and Mnisi said that he needed to put the court in proper perspective as to why he's embarking on this process. He had to remind the court that Brigadier Gininda said that there is no authority that says what specific document must be used when a warning statement is to be taken from the police. He said that in the context of the South African Police Services, he does not represent himself, Brigadier Gininda, as he's standing there as a witness. He's representing the South African Police Services, who's got a minister and a commissioner. So he's basically saying that the National Commissioner is telling this court that there's no authority that says what specific document must be used when a statement is to be taken from a suspect, which is the reason why he is embarking on this process. The judge said that he was just explaining the origins of the law, and this comes from England. The judge said that every warning statement in South Africa since 1996 after the interim constitution encapsulates Section 35 of the Constitution, and the person's rights are encapsulated there, pointing to that warning statement from Nelspruit. That's what's important in this document, he said. So Mnisi said that he had a different view. If the court is reading it in such a cursory way, Mnisi said that they will be waiting for Mongwe to tell them where he got that warning statement from. And Mnisi then went on to the warning statement of Enadale, and Gininda said that they were brought to his attention by Warrant Officer Mokoena from his office, as well as the Boyson one. So Warrant Officer Mokoena wrote, they are part of the cold case unit. Also on those forms, no name was given, as the request for names from Advocate Mnisi was not given, according to Brigadier Gininda. And however, the statement, he said that it was coming and they should have it. by the end of the day yesterday. So after that short adjournment, Mnisi still insisted that Gininda was incorrect. Mnisi said that his version that there is no prescribed form that must be used for a suspect is wrong. Gininda said, I disagree. I'm sitting here with a statement from the head of the police division or the policy division of the SAPS that says there's no specific authority. So Mnisi then told him, you told the court that there's no authority on what document must be used for a warning statement. And Gininda said, I said there is not a specific document, even till today. Okay, Mnisi then told Brigadier Gininda, you are wrong when you say that there's no authority or specific form to be used when a suspect's statement is being taken. Gininda said, I can't say I am wrong. I don't know which authority you want me to refer to. There is no such policy. The judge interrupted Mnisi at this point and asked for the document and said that he did not have them. And Gininda said that he handed it over to the state last year. Baloi handed it over. The judge said that it contained an SAPM in brackets. The M is in brackets. But he will just read what he claims to be the policy. So the judge said that it's not SAP3M that was being debated before court, as Gininda said that it was. And Mnisi said that, to me, guys, I don't want to lie. What I picked up is like, Brigadier Gininda, in my opinion, seems to be clueless about this warning statements process. I don't think he's a fan of this paperwork. I was getting that sense that he's clueless in this department. In my opinion, I felt like I don't think he understands what is required of him in regards to filling out this paperwork. I don't think he's a fan of paperwork. That's my opinion. Well, Mnisi said that he needed to bring the court beta, which is very tricky because now, since he's embarking on a law degree, being a lawyer is all about paperwork. It's reading. It's filling in. It's a lot of writing. So I just don't know if warning statements are dribbling him like this. I got the asazi, guys. Let's just keep it moving. There might be instances where the person that wrote that document into record, there might be instances where a person who wrote that document may be required to come and testify. The judge said that it wasn't a problem. If he wanted to come, then he would issue the subpoena for him. So Mnisi said that let that person rather be the one who will read the document into the record. So Mnisi wanted the person who gave the warning statement to be the one to come and read the statement on record. The author of that statement must be there. But then the judge was not having it. He refused. He said that he's taking the two assertions where Mnisi is saying that there's a policy and Gininda is saying that there's no policy for the warning statement because they can never agree. He asked Advocate Baloi to read Section 234 of the Criminal Procedure Act, and the judge read the statement. It said, Brigadier Peter Willem Ninbar, he is the section head police in the component governance, legislation and policy in the division legal services of the SAPS. He said that he is the custodian of all policy, national instructions and orders in the SAPS. So Magutiwa National, this sounds like a person who's in charge of all the warning statements in the country. So Gininda requested that the directives dealing with SAP3M statement regarding interviews with the suspect, also commonly known as a warning statement. He said, I indicated that I could not find a policy or directive of the South African police specifically dealing with the directives of the SAP3MM form attached. He went to describe what should happen when they enter suspect, reading them their rights. It was signed on the 17th of November 2024. The judge said that the forms on the confession were not similar. He was asking about Miss Villion and Boto, all that came to testify with different forms. He was pointing it out to Advocate Nisi that Miss Villion and Boto came to court and they testified with different warning statements. And he said that all they are arguing about is Section 35. That's all. So the judge was working overtime here, in my opinion, to justify the different warning statements. And obviously, I mean, if you're going to enter the arena and do that, you're obviously doing it for the witness. You know, he could see that the witnesses, this is a weak department of warning statements, which is something he should know and understand, in my opinion, because he's so experienced. He's in managerial position. I mean, he's the boss. He's the head of the court case unit. How come a warning statement's dribbling him like this? And the judge is now coming to his rescue and saying, according to Section 35 of the Judges Act, what? It means as long as you have those conditions, so you can have literally any piece of paper, as long as you make those judges' statements, then that qualifies as a warning statement. That's my interpretation of what he was trying to do. And he said that that's the premier law in South Africa concerning the rights of an accused person. So the judges now recited how Brigadier Gininda took the confessions, and MDC expressed that he was disturbed and was cut off. He was not even given an opportunity to respond. The judge said, "You will read my judgment, no problem, whether you think I'm right or wrong." So this, in my opinion, he was giving it away, further emphasizing that this verdict will come out in a way that will upset most of us. It's already written down. I mean, this is just an irresponsible thing to say, in my opinion. How can you say that? And the worst thing is that at the end of the court proceedings, he was saying that the JP was sitting there at the back. So he had the audacity to tell a defense counsel in front of a JP that the defense counsel will read his judgment, and he will then decide after reading his judgment whether he was right or wrong. Who is the witness here? Like, I don't understand. Prosecutor, judge, witness, prosecutor, witness, judge. Like, I don't understand. Like, how can you say that? How can you say that? It's so disturbing, guys. If this doesn't tell you that the judge is getting his judgment that he has already written, nipped and tucked on a daily basis to come up with, in my opinion, a guilty verdict, I don't know what to tell you. My mind is already made up. I'm preparing for the worst. So also, the energy that I feel Mgomezulu was receiving, Advocate Nisi is now receiving, which means he's doing a good job. He's doing a phenomenal job. And he's very patient. And guys, let us pray for Advocate Nisi. That's just something I want to communicate. Let us pray for him. Let us stick together in prayer. Okay? Let us pray at all times. So Gininda said that it's not true that the conversation he had with accused 1 and 2 was written down. He said he wrote it in his diary and it's in court. So instead of taking a proper warning form from the police station that you detained Danzi at on that night, you write in your diary, And how do we authenticate that what is written in your diary regarding your interview or the brief moment you encountered with accused number 2 back in 2020 was actually written on that night, or if it was written in 2023? Who knows? We have no way of authenticating that. There's no warning statement that he felt on that day and on the days where he had encounters with accused 1 and 2. And by the way, I just learned that he was supposed to fill in a warning statement as they were about to confess, as he was interviewing them and having that conversation with them. Apparently, he was supposed to fill in a warning statement, read them their rights, help them understand what they were about to say, the consequences of what they're about to say. And then he was going to go have them before a magistrate or a commissioner of oaths do the confession. But he didn't do it. Now we're supposed to believe that he read them their rights. We're supposed to take his word for it. And another thing that I think we forgot about, he actually said back when he testified last year that you fill in a warning statement just before the suspect appears before court. How many of you guys remember that? And I ate it up. I was like, okay, maybe that's the case. But now after doing my research, he said it with so much confidence that he waited for the prosecutor to give him a warning statement, and you fill in that warning statement just before you appear before court, or just before you make the suspect to appear before court. I'm like, so Mnisi referred him to a book that was written to the SAPS in its entirety from senior to junior members. It was written by N.N. van Graan and Colonel de Camper. The judge asked if it was the same de Camper on one of the warning statements that he was holding. I'm going to assume it's the one from Nelspruit or something. And Mnisi said that he didn't know, okay? And I felt at this moment, Gary, your Judge Galile Futi started again with his shenanigans of attempting to throw off Advocate Mnisi, always interrupting him and not letting him flow with his cross-examination. Mnisi asked him, he asked the judge, he said, I don't know where the court is headed with this. Mnisi said he does not know him, this Camper. He has never had him. He has never met him or heard of him. If the court asks if it's the same guy, then what is he supposed to say? Nisi asked Gininda if he's aware of the book, and Gininda asked what is the book about. Nisi said that it was about operations within the SAPS, and Gininda said that he was not aware of that title. Nisi also read the list of other authors who assisted in writing of this book. There were many guys. I did not collect those names, but he said there was a Ninaba that he mentioned, and Brigadier Gininda said it is the same brigadier who gave him that statement. And he said that he's aware of De Camper, who was a colonel but now is a brigadier. And Mnisi said that he asked him about the book, not the people. So Brigadier Gininda is saying now he knows the author of the book, but he doesn't know the book. Professor Dugat also was mentioned to be one of the people who also contributed to this book, and he has a very high profile. They are saying that he was in that case, the ICJ, where South Africa was taking Israel to court. Yes, he was there, and the judge said that the Professor Dugat is his friend, and he taught him in words. And apparently he's still there even today. And the judge said that he gave him advice when it comes to international law. He's an expert on international law. There was a terrorism act. There was a time that another judge, I think he mentioned him by name, I forgot what his name is, sent one of his clients, Thelma Muriani, he said that the person got a death penalty. And Ramosipili also said that he taught him adverts. Mnisi finally shared the name of the book as well. And he said that it's called Ikabani, the one that Mr. Anonymous was reading from. Gininda said that he had never heard of that book. And for the very first time, his answer was a sweet no. Yeah, it was very nice. Since Brigadier Gininda was unaware of the book, Mnisi said that he would not be cross-examining him using the book. So Mnisi said, I put it to you that the procedure you used in the interrogation of accused number 2 without using the prescribed form was irregular. And Gininda said, I totally disagree. Prescribed by what policy? Because we are governed by the standing orders insofar as police is concerned. When it comes to the rule of law, it's a Criminal Procedure Act and other related legislation. Now, if I'm being told it's governed and prescribed by what? There's no such policy. I'm not aware of such prescription. So I don't agree with that assertion. I followed what was prescribed in terms of the warning statement. The accused warning the accused according to Section 35 of their constitutional rights and ensuring that he was of clear and a sober senses. He said, I followed what was prescribed in terms of the warning, the accused in terms of his constitutional rights and ensuring that he was in his sober senses. This, for me, reinforced that, in fact, it is a law that every time a police officer interviews you, interrogates you, asks you questions regarding something that you are being accused of, they should fill in that warning statement. This to me, reaffirmed that feeling I had, but I was not sure with certainty. So Mnisi then said on page 18 of that book, it speaks about warning statements, what needs to be done and which form needs to be used. Gininda said he was being put in a very unfair situation because he had not read the book and he had not had that before you become a police officer. They were not told to read the book. It was not taught to him even at college. He said, for me to comment, I must acquaint myself with the book. It's an unfair situation. And Mnisi said, a person at your level, at a managerial level, should be aware of this book. Ignorance of the law can never be an excuse. Baloyi objected Mnisi's statement, saying that it was unfair that he had or that he is ignorant of the law. For the past 2 days, Advocate Mnisi has been busy with the warning statement and purportedly to challenge the evidence of Brigadier Gininda regarding the investigation that he was busy with regarding accused number 2. And Brigadier Gininda mentioned that he was not busy with the warning statement. He was not taking a warning statement. He was busy with an investigation. Don't you investigate first and then arrest? So when you have arrested, are you not in the process of finalizing your investigations? Why is it that people are arrested first and then investigated later? Why is the order like this in this instance? Because part of the reason why there's no warning statements, it means, or in my opinion, the investigation was not done. How do you want to investigate by first arresting a person and then asking them, did you do this? What do you expect to happen? Are you expecting that they will just tell you the truth? Yes, I did it. In what world? Baloyi then said that they quoted an instance of a police officer who sees a person carrying a laptop in a suit. You know, this also, it came and crossed my mind. I'm like, that is why he keeps saying that he was not there every time the accused number 1, in particular accused number 2, were being interrogated or interviewed. he keeps saying he was not there, he was not there, he was not there. And I kept asking myself, guys, I've been asking myself. And today I think it finally dawned on me. It was like an aha moment. I'm like, oh, because he would have to produce warning statements for each encounter he has had with them. And it looks like he's not a fan of filling in warning statements. And it looks like he also likes to send people a lot. Yes, he is a head and he's the boss of his department, but like, that's my opinion, and allegedly that's the feeling I'm getting, that he likes to send, he likes tumana, like tuma. So there are certain things that he honestly doesn't enjoy or doesn't want to do. I don't know how to interpret this, but yeah, that's the feeling I got. I'm like, oh man, this is the reason why he keeps saying he was not there, he was not there, he was not there, he was not. Because for every encounter, there had to be a warning statement. So Mnisi objected and said that this is argument. If Mr. Baloyi wanted to take this up, he will have ample opportunity in re-examination. And he said that this is highly unprocedural, what Advocate Baloyi was doing. But then the judge, being the judge, said to Advocate Mnisi, let him finish. He wanted Advocate Baloyi to finish. And Mnisi said that if the judge is condoning it, and the judge said, I'm not condoning anything. You're talking about textbooks and some people being ignorant, etc. He said, I'm sure you can be allowed to tell us what you think. And Baloyi said that Mnisi was busy with collateral issues, and the issue of a warning statement is a collateral issue. He said that there was no need for Gininda to take a warning statement at that stage, and he was busy with an investigation. He did not arrest them or charge them. He could then make a warning statement, and he was busy with an investigation. And a warning statement followed much later. So Mnisi asked him to reply to what Advocate Baloyi was saying. He said that the state is lost because at the center of what they are busy with, there was a statement that was introduced. The wording of that statement said that each time a suspect is interviewed, a warning statement must be used, and that is the gist. And Brigadier Gininda said you can only use this statement when you consulted with the DPP and prosecutors. He then said that he would take it up in argument, and Baloyi wanted to respond and said that the form said that the station commander must consult with the prosecutor in circumstances in which the prosecutor requires a warning statement. So yes, exactly what he had read, he was not wrong, but this passage he just read was talking about the prosecutor, not the police officer. The prosecutor is the one who they require a warning statement just before a court. He's not talking about the police officer. So Mnisi asked the judge about the professor again, who wrote the book, Iqabani. And he informed the judge that he was reading a lot of relevant material. He asked to approach accused number 3, and when he came back, he said that he had no further questions, so he wrapped up his cross-examination. So Judge Mokgwatleng asked Mnisi if he still wanted to continue launching that application because the JP was sitting at the back. Is this the same application that Advocate Mgomezulu wanted to launch? And he said that he is concerned, the JP is concerned about the pace of this case. So I don't know whether the JP is only concerned when applications are being brought up, or when there's a feeling that the defense are the one causing the pace to be slower. Every time it's happening on the state side, the JP doesn't have comments via Judge Ratha Gininda that are being expressed. But every time, like for instance now, it's not a secret, and we were all anticipating the fact that Advocate Mnisi is going to need time to go through the case of accused number 1. Remember, he did not represent him before. This was Advocate Mgomezulu's client. It was not Advocate Mnisi's client. So he was focused on accused number 3 and the defense of accused number 3. Now he has to compile the defense of accused number 1 from scratch based on what he knows, based on what he can recall. He has to start all over again for accused number 1. Yes, he's been there in the case, but Mgomezulu was a rare breed. Mgomezulu came into this case, hit the ground running, but I wouldn't expect, or it would be unfair for Advocate Mnisi to not be given a chance and time to go through. He's not asking for 2 years or 2 or 6 months. He's just asking for 2 weeks, right? And he wanted to have a chat with JP. Apparently, according to Judge Ratha Gininda, he was saying that the JP wanted to have a chat with all the legal counsel. So Mnisi said that, as he had indicated to court in the chambers, he had accepted to represent accused number 1. And he said, I deem it prudent that I be afforded the opportunity to read the records as they relate to accused 1 and all these assertions made by him, and consult with him of whether he has witnesses. He said that he requests that can be afforded, or to be afforded the opportunity, because this reading that he has to do is quite voluminous. It can be afforded an opportunity. He was asking for 2 weeks to read through the records of about 35,000 pages. I can only imagine, guys. It's a lot. And the reason why I'm understanding of Advocate Mnisi needing more time, because even I, although we do the case every night, there are some points that I struggle to recall. So can you imagine now having to switch your mind from I'm focusing on accused number 3 to now having to do it for accused number 1? He has to start from scratch. He has to start from the beginning, and maybe he may discover new loopholes that he didn't pay attention to before in the past. He needs to craft a defense for accused number 1, and he has to consult with him as well. So it's only fair, it's only reasonable. I don't think it's a unreasonable request. I mean, before we had to wait something like 2 months for Advocate Mshololo to go through docket 375. So 35,000 pages, 2 weeks plus consultation. It's not an unreasonable request. So he said, I'm unable to start now with the cross-examination on behalf of accused 1. And Advocate Baloyi said that these are unusual circumstances. Nobody could have foreseen the passing of the legal representative of accused number 1. And he said that they have indicated that they're not going to object Advocate Mnisi's request. So yes, the trial has been postponed to the 3rd of February 2025 to allow for Advocate Mnisi to prepare the defense for accused number 1, Moses Bia. And Mnisi had agreed to represent him after the passing of Advocate Mgomezulu in December last year. So Mnisi said that he deemed it prudent that he be afforded the opportunity to read the record as they relate to accused number 1 and all these assertions made by him, and consult with him of whether he has witnesses. He said that he would request that he be afforded the opportunity because these readings were voluminous. So those are 35,000 pages that he has to go through. And he said he was unable to start now with the cross-examination of accused, or on behalf of accused number 1. So guys, that was it. That is a wrap from me. I hope you are liking the video, guys. Please press the like button, okay? For now, I'm just going to go through your comments, you guys, and wait for the response. But I don't think we'll be taking calls today. It's quite late and there's a lot happening, so I'm waiting for feedback as to what to do next. So yeah, guys, that is it. Right now I'm trying to look at your comment.
It's chai time, guys. Take calls tomorrow, I think. We're gonna make a session or something like that. We'll see. We'll discuss how your day is. then we'll see, maybe we can squeeze in something. But for now, it's late because of the problems. We started late, so thank you again to everyone. I cannot mention one by one today, but thank you, and smash that like button on your way. Let's push to 200, and that would be great if we can do that.
We have to come back tomorrow for calls, guys. We have to come back. We need to talk to you
so
guys.
I'm even trying to squeeze in all the comments as much as I can, but I'm sure there's a lot of them. Thank you, guys. Press that like button. I'm just in waiting, saying press that like button. Let's see if we cannot reach 200 and something. We have 107. We have 300 people here. Thank you very much for joining us, even if it's this late. Thank you. We appreciate you. Sorry for starting late. It's because of the things that we can control. And that's why I was quiet. Let you, Emily, run as fast as you can, because it was tough. It is even tougher for me because I have to go to office tomorrow, but I'm here. Thank you guys for just press that like button. Everyone was here. We appreciate you, and everyone who did something. Thank you. Who liked, someone who joined membership, someone who. Thank you. Thank you very much.
So be on the lookout tomorrow. We're definitely gonna go live, and so that we can receive your calls, guys. But for now, thank you so much.
On your way out,
the next one,
smash that like button like your many. Thank you.